this honorable court are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
You may be seated. All right, we're ready to hear argument in the next case, and petitioner, you can go ahead.
Your Honor, may it please the court. My name is Jenna Lawrence, and I, along with my co-counsel, Bo Marr, represent the Wildlife Protection Council. At this time, may I please reserve 2 minutes of both myself and my co-counsel's time for rebuttal?
You may.
Thank you, Your Honor. We ask this court to rule, first, that FERC acted arbitrarily and capriciously when they failed to reinitiate consultation with the FWS regarding new information that they could not have previously considered. And second, we ask this court to rule that FERC was the improper actor to determine—
Ms. Lawrence, we have two statutory schemes here. The Endangered Species Act and the National Environmental Policy Act. Is the standard for what's arbitrary and capricious the same under both acts, or is it different? In other words, do we have to do two analyses, one under each act, or can we look at it one time and that's it?
Your Honor, while the analysis of what would be relevant data and whether or not that data had been articulated to be connected to the decision of FERC, the standard of arbitrary and capriciousness is the same under either action. I will be discussing the ESA questions, while my co-counsel will be discussing the questions that arise under NEPA, where FERC failed to fulfill their statutory—
There's a case law that supports that proposition that they're the same.
Your Honor, the case law that this court decided in the Auto Manufacturers Association against State Farm discussed that the arbitrary and capricious standard requires the court to examine two things. First, whether an agency has considered relevant data, and second, whether there is an articulated connection between that relevant data and what is actually determined by the agency to be correct. So the determination of what is relevant will obviously change depending upon the statutory scheme that is established. When we look to the first question of whether or not FERC failed to reinitiate the consultation, we can see that this is arbitrary and capricious because they neither considered the relevant data or even
Which relevant data are you referring to?
Your Honor, there are two pieces of relevant data that FERC ignored here. The first piece of data is that the furry aphids, which affect the hemlock tree, the critical habitat of the warbler, these aphids have now been found in the forest. And the second is a May 2015 peer-reviewed study discussing how the aphid spread has increased and is now moving even faster than had previously been determined.
Well, I'm glad you got to that quickly, because my question on that study is, would FERC have had notice of that study, actual or constructive? It's a peer-reviewed publication, as I understand it. But how would FERC have notice of that one study, which really didn't, it just made some suggestions, didn't it?
Your Honor, under 402, the regulations dealing with this situation, FERC has an affirmative duty to look and see whether there is information that means that the agency action will have effects on an endangered species in a way that is increased that had previously been considered. So while our record is unclear as to if FERC had actual or constructive notice of this information, FERC had the affirmative duty to be monitoring to see if there was a change in the environment.
Where does that affirmative duty come from?
Your Honor, this affirmative duty comes from the regulation 402.02, which discusses how FERC must reinitiate consultation with the Fish and Wildlife Service if there is new information that arises. It does not say new information that FERC has knowledge of that arises, but rather if this information changes.
Does FERC have to reinitiate the consultation under any new information, or is there a particular standard that we should be focused on for determining whether FERC acted in an arbitrary and capricious fashion?
Your Honor, the standard is that FERC needs to reinitiate consultation when this new information reveals that the agency action, so laying this pipeline, allowing this pipeline to go forward, would have an effect on the environment to a manner or to an extent that is greater than what appeared before. In this situation, we would be looking at a greater extent than what appeared before.
How do we know that? Where in the record is there any indication that there will actually be an impact to a greater extent as to what, than the agency considered already?
Well, first, Your Honor, we have nothing in the record that notes that the agency even considered the aphid's effect on the habitat of the warbler. All it merely says is that they considered the habitat, but there's nothing in the record that notes they even considered the aphid at all. Even if FERC considered the aphid at all, the fact that the aphid has now arrived in the Andorian National Forest and is spreading more quickly than before shows that the effect of then fracturing another part of this increasingly diminished habitat would show a far greater effect. Because of this, FERC should reinitiate the consultation with FWS. The greater issue here, the issue here that FERC also fails is even if FERC says we knew about the aphid, we considered it, and we determined that it was unimportant, is that the standard of arbitrary and capriciousness requires that FERC articulate a reason between this information and their decision. If FERC simply just determines that this is unimportant, they need to articulate that under State Farm in order that a reviewing court may examine the record and may examine FERC's decision to see whether it was arbitrary and capricious.
But aren't you assuming that, based on this peer-reviewed study, the spread of the aphid will decimate the hemlocks? Isn't that something that's not in the record?
Your Honor, it is not necessary to determine that the spread of the aphids will decimate the hemlocks. What is in the record is that aphids are killing the hemlocks.
But they have been. This is not new.
Your Honor, aphids had not been found in this particular stand of hemlocks. And then, under the peer-reviewed study, while aphids had been killing the hemlocks at a certain rate before, that rate has now increased. So we both have aphids in an area that they were not previously, moving more quickly than they were.
Isn't this particular stand of hemlocks going to be cut down as a result of the pipeline? So that's been considered, and what the impact would be on the warbler of the cutting down those hemlocks. So what's the difference? It's the same trees.
Your Honor, all of the hemlocks affected by the aphid will not be affected by the pipeline. The entire forest currently exists with hemlocks in it, and this current proposed pipeline will go through a portion of those hemlocks. The aphids have appeared in a different sector of the forest, so while perhaps there will be some trees that are affected by both the pipeline and the aphids, there are a greater number of trees that are now affected by the aphids that previously were affected by nothing. Therefore, the total amount of the critical habitat for the warbler is going to significantly decrease. Furthermore, this evaluation of what type of impact the aphid would have needs to be done by the Fish and Wildlife Service. The Wildlife Protection Council is asking that this court cause FERC to reinitiate that consultation, and that the Fish and Wildlife Service, who has the expertise in these environmental areas, is able to do a proper evaluation of this new and relevant information.
You've got some other arguments besides the aphid, though, don't you, that'll prop up your argument a little more if you lose on the aphids?
Yes, Your Honor. Our second argument is that FERC was the improper actor to consider environmental alternatives in this situation. Now, according to National Association of Home Builders Against Defenders of Wildlife, when there has been a jeopardy determination, which we have in this case, jeopardy for the warblers, the FERC has three options. The first option is that they may simply discontinue the project, no pipeline at all. Their second option is to implement one of the reasonable and prudent alternatives proposed by FWS. And their third option is to apply for an exemption under Section 1536HA. In this case, FERC has done none of those things. They are allowing the pipeline to go forward. They have not allowed any of the reasonable and prudent alternatives by Fish and Wildlife Services to be adopted, nor have they applied for an exemption under this case. Now, according to Tennessee Valley Authority, the snail
Well,
dart...
what would be the reasonable alternative in your client's position?
Your Honor, we would ask that this court allow Fish and Wildlife Service to propose those reasonable alternatives and to consider those economic factors there, as both the statute and the regulation require. And, as the Fourth Circuit pointed out in the Dow AgroSciences case, is the appropriate place for those economic factors to be considered. that the Fish and Wildlife Service is the one to consider these reasonable and prudent alternatives, and under those reasonable and prudent alternatives, they must consider economic feasibility.
So in Dow AgriSciences, couldn't FERC say it's the agency that's supposed to consider the economic consequences of selecting an RPA?
While FERC may say that, Your Honor, in Dow AgroSciences, the Fourth Circuit there was specifically addressing whether the Fish and Wildlife Service may evaluate those economic alternatives. Furthermore, when we look at the regulation 402.02, which discusses what economic factors and where they should be considered, it discusses it being considered under the initial consultation for the biodiversity where the reasonable and prudent alternatives occur. Even if FERC says we have an economic concern about what is occurring, the statute allows for them to raise that concern through an exemption process.
There
FERC
were a
can,
couple other pipelines companies, or at least one, weren't there, that offered an alternative, and that wasn't considered at all, was it?
That's correct, Your Honor, that FERC did not consider those alternate pipelines. And furthermore, FERC did not consider the reasonable and prudent alternatives offered by the Fish and Wildlife Service.
Well, the other pipeline might be a reasonable alternative, might it not?
It may be, Your Honor, but unfortunately, FERC has declined to articulate the difference, the reason, and how they've gotten from this information to the decision that they have before them. There may be reasonable and prudent alternatives that are available that FERC has not considered, which is exactly why FERC has acted arbitrarily and capriciously here. FERC does not have the...
They don't have to consider every possible alternative, do they?
No, Your Honor, they do not. But FERC does have the duty to consider the reasonable and prudent alternatives proposed to them by the Fish and Wildlife Service, which in this case, they did not. Instead, FERC decided to independently come up with some mitigation factors. However, FERC does not have the environmental expertise to determine what mitigation factors would effectively actually achieve the goals of the ESA and achieve a change of the jeopardy warning on the warbler.
Now, is your argument that FERC should have considered other routes as an alternative? Is that the point you're making, or are you saying that it wasn't up to FERC to do that?
Your Honor, petitioners argue that this was not FERC's responsibility. FERC either needed to consider the other routes that were proposed by Fish and Wildlife Service or apply for an exemption.
But FERC did consider the other
Yeah.
routes, didn't they, and found them to be, A, very expensive, and B, cumbersome, for lack of a better word.
Your Honor, FERC dismissed out of hand several of the routes, failing the second prong of the arbitrary and capricious test. And then second, FERC made a decision based on economic factors, which under 1536HA, if that is a concern that FERC has, their only remedy for that is to go through the exemption process, where the statute has set up an entire committee to hear these types of concerns. This is not for FERC to decide. And for these reasons, we would ask this court to grant our petition for rehearing.
Mr.
Thank you.
Marr?
Your Honors, and may it please the Court, my name is Bo Marr, and I represent the Wildlife Protection Council, the petitioner in today's matter. Your Honors, we asked
You're
this...
not related to that Bill Maher who's on TV, are you?
No, can't say that I am.
Good.
So today we asked this Court to rule two things. First, that FERC was unreasonable in its cumulative impact analysis. Second, that FERC was unreasonable in both the scope and the depth at which it considered alternatives. We'll start with the cumulative impact analysis. And here, in 40 CFR 15087, the regulations instruct FERC to look at major federal actions that are either past, present, or reasonably foreseeable in the future. Here, the MIT2...
How do you define reasonably foreseeable in the future?
Yes, Your Honor. Today we'll be looking specifically at that point and how to decide that. First, you look towards whether or not those pipelines are similar to the current pipeline. You also look towards how speculative those pipelines may or may not be, and when FERC was on notice that they may be built. to start off with how similar the MITU and the NME are to the current pipeline. We look at two different things, a temporal element and a geographic element. And if either of these are similar, then we can go ahead and call these pipelines similar. So starting with the temporal element. Here, we see that the regulation specifically states that you can consider this over a period of time. These pipelines do not have to be built at the same time as each other. So though these other two pipelines...
They should have to be built at some relatively close time period, shouldn't they? Here, it appears that the other two pipelines are at least 2 years behind if they are ever to be built at all.
Yes, Your Honor, they are exactly 2 years behind. And because pipelines take a long time to build, we would argue that 2 years on the whole is not actually that long. But further, we would look at the record on page 9, and we would look towards this proposed parallel power line. Now, this was considered by FERC. FERC looked at this power line, and all that's in the record is that it's both proposed and parallel. And they decided that is likely enough and needs to be considered in the cumulative impact analysis. And we would argue that this is completely analogous to the MITU and the NME.
Well, if they're parallel to it, how would the potential impact be any different than it already is? How would a potential cumulative impact be any different than the impact of the Mammoth pipeline if they're running parallel through the same area?
Your Honor, the reason why that we need to include this here is because parallel would further fragment the forest, and that would affect where we place the Mammoth pipeline. And so what we need to see is this is similar to if you're driving down a road by yourself, you can drive anywhere on that road. But if there's two other cars that could potentially be on that road, you have to pick a side. And so factoring these in now can affect where the Mammoth pipeline is going to be built. And that's where we move into the geographical portion of the similarity analysis. And we see that this parallel route is enough to say that they have a similar geography and should be considered. But we'd also look at how speculative these pipelines may be. And we would see that they have already contracted for 55% capacity each. And that we would argue that is enough to make them at least viable enough to where FERC would have to consider them
So
in this.
what's the tipping point for viability? 55%? What if it was 50-50? It's pretty close to 50-50.
Your Honor, we would not advocate a bright line, but we would say that FERC cut off consideration before they had chances to run mitigation procedures to up the amount of subscription. For example, the Tennessee gas pipeline currently being proposed in New England, when they had a 40% subscription, they actually moved from a 36-inch diameter pipeline to a 30-inch diameter pipeline. And so the ratio boosts the amount of subscription.
Mr. Marr, the state of Franklin has its own Clean Energy Act here. How does that figure into this, if at all?
Your Honor, that would not figure into the cumulative impact analysis. On the second point, the type of alternatives to be considered, that would come in. And so moving towards that second point, we see that today we ask that this court hold that FERC was unreasonable in the scope and the depth at which it considered alternatives.
But
Are
to
you
follow-
saying that the cumulative impacts analysis is one of the factors to be considered and then therefore subject to the arbitrary and capricious standard? Clarify, if you will, what flexibility the agency has to consider these two pipelines or not consider them, because it sounds like there's a reasonable disagreement about whether they even should be considered. If that's the case, and we defer to the agency, that could be a material difference for you and your client.
Yes, Your Honor. And I would bring up what my co-counsel had mentioned in Motor Vehicles Against State Farm. Here, we have to have a rational relationship between the data and the articulated decision. And we would say, though we would admit that we should defer to FERC, they, in the record, stated no reason why they did not consider these pipelines. And
Does
so,
that reason have to be stated? What case do you rely on for that proposition?
Your Honor, I would rely on the same case that my co-counsel brought up, Motor Vehicles Association Against State Farm, where they state that it has to have this articulated rational relationship. Under NEPA, the whole idea is to provide the public with information. and kind of look into the mind of FERC to make sure that we're making an educated decision. And so if FERC is not going to provide us with that information and articulate that rationale, then that would fall under being arbitrary and capricious.
So, as I understand it, the Marsh case and other cases say that courts don't have to defer to, or doesn't the court have to defer to FERC since it has the technical expertise, unless it has not made a reasoned decision. So articulate for me why FERC did not make a reasoned decision, assuming that it had the expertise and we deferred to it.
Your Honor, we would say that that is not in the record, and so that we don't know how they made that decision and whether or not it was reasonable. So even if we go with this hypothetical that they have this deference and they have this expertise, they did not articulate that for us, and so we are arguing that that in itself is arbitrary and capricious. Now,
The section of the Administrative Procedures Act that states the standard review says it's arbitrary, capricious, and abuse of discretion or otherwise not in accordance with the law. For some of us, those terms have different meanings. I mean, abuse of discretion is a more deferential standard. Arbitrary and capricious maybe is a little harder. So how do you define which standards you proceed under the Administrative Procedures Act?
Your Honor, here, under NEPA, we would state that we are arguing this under arbitrary and capricious. And though, as you noted, that is a higher bar, the second step, as my co-counsel stated, is that this has to be articulated somewhere. And we see that it just was not. And so we meet that high bar here today.
Does your client, as a petitioner, have any role in this process while it's moving through the administrative phase? Do you have an opportunity to watch it proceed?
Your Honor, the part where we would be able to, I guess, comment would be in the comment period after this decision was finalized, which was in May. However, what we need to comment on has to be in the record. And so what we're arguing here is that to allow us to articulate our decisions and see how the FERC made their decisions is it has to be in the record. They have to show their rationale because that's what makes the comment period worthwhile.
Does that mean that your client and clients similarly situated can just sit back and watch it and then critique the process after it's all finalized and during the comment procedure?
Your Honor.
And did you raise these issues during the comment procedure?
Your Honor, well, it is not clear in the record who raised what in the comment period. The comment period is for raising these types of concerns, but we found in that period that it was not in the record, and that's why we're here. Now, in the second point that I would like to talk about is the scope and depth at which these alternatives were considered. Now, we would argue that under 42 U.S.C. 4332, we look towards the purpose of this project. And here, that should be broadly construed. We see that the whole idea behind this was to provide lower carbon energy to Franklin. And so when we look towards the alternatives, we look at them kind of in that light, that they're supposed to apply or bring lower carbon energy to Franklin. Looking at the first point.
That's all pretty speculative, isn't it? I mean, shouldn't we confine our analysis here to the pipeline and not go out into the stratosphere and speculate on what alternatives might be that might never occur?
Your Honor, we would look towards Vermont Yankee versus the NRDC from the Supreme Court. Now there, they articulated that alternatives, specifically to energy projects, are evolving. And we can see here that in 2016, we have alternative energies that have reached grid parity.
Did they say the fact that they were evolving requires them to be considered in that case?
Your
How far
Honor,
did they take the point?
Your Honor, in that case, they were dealing with a nuclear power plant. So, and again, it was in 1978, and they did not evaluate the same alternatives that are evaluated here. Now,
I wanted to go back to what the purpose of this project is, and maybe it's a semantical difference only. I thought it was to provide natural gas transportation. and I understand that you're talking about clean energy alternatives. Do we mean the same thing?
Your Honor, we would argue that it is broader than just to provide natural gas.
But that is
And-
what the FERC said the project's purpose was. That's what the applicant said the project's purpose was, correct?
Yes, and we would argue that they too narrowly construed this because it has to be broad enough to be, to have reasonable alternatives under the statute.
Well, under the statement of the project as it was presented below to the agency, weren't 10 alternatives to that purpose considered, to the pipeline for that purpose considered by FERC?
Yes, Your Honor.
And that
However,
included wind and solar and nothing. I mean, no action was one of the alternatives, correct?
yes, Your Honor. They considered each one of those individually. However, given that the current portfolio of energy in Franklin is a combination of wind, nuclear, solar, we would argue that they had to consider some type of combination in order to adequately inform the public about this project and the alternatives to it. Furthermore, they had to look at alternative routes. And this is where they were probably the most arbitrary and capricious. The alternative routes, there were 11 different ones. Only 2 of them are in the record as having been evaluated. Only 1 of them was evaluated thoroughly. The other 9, there is nothing in the record on page 8 that states why they didn't choose them, why they excluded them. And so when we look again towards Motor Vehicles
One of them
Association
went through
against...
some wetlands where there were some other endangered species, didn't it?
Yes, Your Honor.
Didn't that justify them not pursuing that any further?
Your Honor, my time has expired. May I briefly conclude?
Well, that's up to the...
You may answer Judge Faber's question briefly and then conclude.
Yes, Your Honor. Your Honor, while 1 of those 11 did go through marshland and was excluded for that reason, the other 9, we do not have in the record why they were excluded, and that would be arbitrary and capricious. For these reasons, Your Honor, we would ask you to deny the petition for rehearing, or grant the petition for rehearing. Thank you.
Thank you. We'll hear from respondent now.
Good afternoon, Your Honors. Excuse me, and may it please the Court. My name is Nick Larmer, and along with my co-counsel, Chris Hagen-Fredrickson, we are here on behalf of the Federal Energy Regulatory Commission, or FERC. Your Honors, this is a case of an expert agency acting within the full scope of their statutory and regulatory authority. As such, a high degree of deference should be given to an expert agency when questioning the federal agency acting within the scope of their regulatory authority. Of the 4 issues before the Court today,
Didn't FERC owe some deference to the Fish and Wildlife Service and their recommendations about this?
while FERC does owe a degree of reference to the deference to the Fish and Wildlife Service, Your Honor, under the Endangered Species Act, Section 7, FERC can ultimately conclude not to endorse any of the Fish and Wildlife Service's recommendations. However, if they do so, they are subject to the penalties, both civil and criminal, under the Endangered Species Act. Meaning that even if Fish and Wildlife Service were to say you must place this pipeline through this route, FERC has the ability, as an expert agency, to determine whether to disregard that option or not, subject to penalties if it is deemed.
So are you saying they just disregarded Fish and Wildlife in this case?
Absolutely not, Your Honor. In this case, FERC looked to the recommendations of Fish and Wildlife Service proposed and ultimately concluded that what Fish and Wildlife Service was proposing was unreasonable in and of effect, that the only true recommendation that the Fish and Wildlife Service gave in terms of alternate pipeline routing was the southernmost route. And FERC determined that that route would be cost prohibitive because it would cost $1 billion additional on top of the already $4.4 billion proposed, meaning the pipeline that the Fish and Wildlife Service recommended would be over 25% more expensive. And being as that would be cost prohibitive, the state of Franklin would have to continue to use 82% coal-fired power plants for their energy portfolio.
So even if FERC reinitiated this project, the evaluation of this project, and did find that the aphids were going to kill every hemlock and thereby every warbler in the forest, still doesn't matter? Economic feasibility weighs out?
It should
Wins
be
out?
it should be a balancing test, Your Honor. And opposing counsel cites Dow AgroSciences LLC versus the National Marine Fisheries Service as a pivotal case in this issue. And we implore this court to adopt the Fourth Circuit's holding in that case. In that case, the court held that the economic feasibility is not necessarily trumped by the primary purpose of the Endangered Species Act in protecting a listed species, meaning there should be a balancing test provided between the expert agency and as well as the listed species being protected. Within the economic considerations of how the pipeline ought to be considered, if the pipeline cannot be constructed as a reasonable and prudent alternative.
Did FERC do the balancing, and if so, how did it articulate the balancing?
In this particular case, Your Honor, the balancing FERC decided with was that the Fish and Wildlife Service's recommendation was simply cost prohibitive to the construction of the pipeline. But furthermore, FERC concluded that the route through the Fiddlehead Valley would be the most cost-effective, but also potentially the least damaging of the other proposed alternative routes to the warbler, because the Shady Holler route that was proposed was also rejected because it was a more dense strand of hemlocks within the Eldorian National Forest. And as opposing counsel has stated, the warblers are dependent upon the densest accumulation of hemlocks within the Eldorian National Forest.
So it sounds like FERC knew about the Wildlife Protection Council's position, or there had been some expression of its position during the evaluation process, or did I hear you wrong?
Your Honor, the record is silent as to whether FERC did or did not know about Wildlife Protection Council's objections before the petition for rehearing. The only seminal sort of resemblance that we have is that the study that was released in March of 2015 and the detection of the aphid in the northeast corner of the forest was in 2014. All of those occurred before the final EIS was published in 2015, in May 22nd of 2015, meaning FERC may have known, but the record is completely silent as to whether or not they chose to disregard or in fact did not know of the aphid's impact on the Eldorian National Forest.
What did the March 2015 study by the Association of American Arborists, what did it say?
Particularly, the study found that the spread of the hemlock fury aphid may somehow be increased over the next 20 years and could affect the forest. However, the study was speculative at best in terms of its overall conclusions, because the pivotal point of that study was that warmer temperatures during the winter are what is causing a rapid spread of the aphid. However, the study does not protect continually warming prediction of temperatures in winter, meaning a cold winter might occur within the next couple of years and destroy the rapid spread of the aphid accumulation. The study could also not predict, some sort of pesticide being developed that could prevent the hemlock fury aphid from even continuing to exist, meaning the study says within 20 years there might be a spread of this aphid throughout the forest, which might have devastating effects.
So it sounds like the FERC had knowledge or notice of the study. Is that what you're saying?
Ultimately, the record is silent, Your Honor, as whether FERC did or did not know. The only, as I stated earlier, the only seminal resemblance that FERC have is that the draft or the final environmental impact study was published after the study was published by a couple months, Your Honor.
So you're saying if we had known about it during the process, we wouldn't have, here's the reasons why we wouldn't have thought it was germane or appropriate. Is that what you're?
That very well have made that may have been the case, Your Honor. FERC may have decided to disregard the study as far as its speculative nature in terms of environmental impact. But also, FERC is not under a duty to reinitiate consultation based off of one study proposed. Under Section 402.16, as opposing counsel stated, that
You're correct on that point, but just to follow up on what Judge Stamp, the point he's making, it's a very important one. I mean, you don't need to make a good argument on this issue. You need to win on the issue that the hemlock's rapid decline doesn't change the effect of the project on the warbler's critical habitat. And it does look like, although you discounted it, it does look like climate change was considered in that study. Where in the record are we seeing that it wasn't considered or that it was speculative on that point?
Climate change was considered in the study, Your Honor, but the amount to which climate change will continue to affect global temperatures throughout the winter months was not something that was occurring within that study. The study only stated as a speculative reason that the spread of the aphid that is occurring now is a result of climate change. However, the study does not.
It doesn't, to follow up on that, doesn't FERC have a continuing duty to monitor potential changes to the critical habitat? And if that's the case, and the Fish and Wildlife Service has put FERC on notice now of the study, why wouldn't the FERC go back and take a look at that under the continuing monitoring duty?
Your Honor, if that were to have occurred in this case, that may rise to the level of arbitrary and capricious. However, nothing in the record states that Fish and Wildlife Service requested a reinitiation of consultation over the hemlock fury aphid. In fact, Fish and Wildlife Service, who is the expert on organisms and ecological systems, would have the obligation to request reinitiation of consultation over the new impact of the hemlock fury aphid.
But it did propose an alternative route.
It did, Your Honor. The southernmost route was proposed by Fish and Wildlife Service, and that route would be cost prohibitive, meaning the pipeline would not be constructed. Mammoth could not afford that extra billion-dollar investment in order to create the pipeline through the southernmost route proposed.
So is your argument that Fish and Wildlife, while it suggested an alternative route, didn't do it based on any new study concerning potential future damage to the critical habitat?
The record is silent as to why Fish and Wildlife Service proposed the route based off the impact of the hemlock fury aphid. The only thing stated in the record is that that would be a no jeopardy to the warbler because it would avoid the Endorian National Forest altogether.
And why isn't FERC required to choose the alternative that avoids jeopardizing the endangered species?
Particularly because, Your Honor, under Section 40202 of the Code of Federal Regulations, it indicates that reasonable and prudent alternatives are something that are consistent with the primary purpose of the project, but also economically and technologically feasible, meaning to be consistent with the primary purpose, the southernmost route proposed by Fish and Wildlife Service would not be economically feasible or consistent because the pipeline
What
would.
about the Supreme Court's holding in Tennessee Valley Authority? Doesn't that indicate that FERC is to ignore economic impacts in making these decisions?
Tennessee Valley Authority, while originally a seminal case in the Endangered Species Act litigation, is no longer such the case. A mere 5 months after the Supreme Court handed down the case in Tennessee Valley Authority, Congress was enraged and amended the Endangered Species Act to include the economic feasibility language that exists today. Also, as opposing counsel stated, they included the creation of a commission that allows for an agency to jeopardize a species if it is deemed economically in the best interest for public policy. But furthermore, the Supreme Court itself has backed away from the holding in Tennessee Valley Authority versus Hill. In the case of Bennett versus Speer, the Supreme Court held that economic consequences are an explicit concern of the Endangered Species Act. Keep in mind, Bennett versus Speer was decided after the amendments in 1978, but also the amendments in 1982, where Congress continually increased the amount of economic language within the Endangered Species Act. Meaning that while originally the no jeopardy opinion might be the only possible route for FERC to consider, however, Congress explicitly stated in the seminal amendments, as well as the Supreme Court in the case of Bennett versus Speer, that economic considerations are something that the agency ought to consider when determining whether to engage in an agency action. But furthermore, Your Honors, when looking to opposing counsel proposes 3 possible alternatives to why the no jeopardy opinion may or may not be the best possible thing. Either FERC could discontinue the project, engage in reasonable and prudent alternatives, or seek an exemption. However, the agency control over the pipeline begins and ends with FERC. FERC is the sole provider of discretionary control over the agency action. And because of this, FERC, when they considered the reasonable and prudent alternatives, engaged in a multifaceted analysis of every possible reasonable and prudent alternative. As Your Honor stated earlier, the northernmost route considered would go through a series of wetlands and also propose jeopardy to 2 other endangered species, such as the lonely mountain salamander and the eastern bog turtle. As such, FERC rightly concluded that that would not be the best option for the pipeline. But furthermore, even if the pipeline were to be routed through the Shady Holler route as considered by opposing counsel, that route would only be speculative in terms of how it would provide some sort of ecological benefit to the warbler. As I stated earlier, that is the most densest form of the hemlocks within the Ecuadorian National Forest, but also of the 1,500 golden-throated cerulean warblers within the Ecuadorian National Forest, only 50 nesting pairs of birds are found within the Fiddlehead Valley, meaning through proper mitigation measures, FERC could completely avoid some sort of jeopardy towards the golden-throated cerulean warbler. Opposing counsel states that FERC does not have the decision as an agency to determine if mitigation measures would be acceptable. However, under a Fish and Wildlife Service recommendation, mitigation measures have been used successfully in the past, and the failure to use mitigation measures might be something that was arbitrary and capricious. Because FERC has instituted mitigation measures in this instance, and the proposed pipeline route could avoid the densest form of hemlocks and still be the most cost-beneficial approach to the creation of the pipeline, the Fiddlehead Valley route would FERC's rational connection to the decision to route the pipeline through the Fiddlehead Valley is the only articulable route that would provide a low-cost energy to the state of Franklin, as well as decrease their dependency on coal-fired power plants, which currently make up 82% of their energy portfolio.
What kind of, you articulated the three things that your agency could do, and your opposing counsel mentioned an exemption. What kind of exemption would they consider? Do you have to consider an exemption at all if you've already decided you don't have to do the first several factors?
The exemption opposing counsel referenced was in creation, or it was the commission that was created under the 1978 amendments of the Endangered Species Act, indicating that if a jeopardy opinion was handed down by the Fish and Wildlife Service, the agency could seek an exemption from the commission that was created under the Endangered Species Act. While the record does not indicate that FERC sought this exemption, FERC continually acted in a rational connection with the facts to engage in a reasonable and prudent analysis based off the cost of the pipeline, as well as the alternative routes being potentially harmful to the listed species at case, the warbler, but as mentioned previously, the two other endangered species, such as the lonely mountain salamander and the eastern bog turtle. So in light of these considerations, Your Honors, we ask this court to hold that FERC was not arbitrary and capricious in their decision to not reinitiate consultation over the hemlock fury aphid, but also the economic considerations of the reasonable and prudent alternatives was not arbitrary and capricious. As such, we ask this court to deny petitioner's request for rehearing. Thank you.
Thank you. We'll hear from your co-counsel.
Good afternoon, Your Honors, and may it please the Court. My name is Chris Hagen Fredrickson, and on behalf of the respondent, Federal Energy Regulatory Commission, I will be presenting the latter two issues of this appeal. First, FERC's cumulative impacts analysis was not arbitrary and capricious for three reasons. The Me-Too and NME pipelines were not concurrent to the Mammoth Pipeline, they were not similar to the Mammoth Pipeline, and they were not connected to the Mammoth Pipeline. Second, FERC's alternatives analysis was also not arbitrary and capricious for two reasons. FERC both clearly defined and followed its stated objectives, and under this court's rule of reason doctrine, FERC performed a reasonable analysis of the alternatives on an individual basis. Being part of an agency necessarily entails tough judgment calls, and it is paramount that this court grant deference to what an expert agency feels is the best way to solve a given environmental problem. The court has established the rule of reason doctrine, which requires that agencies take a hard look at environmental questions presented before them. But this court...
So wouldn't that mean they need to take a hard look at all the possible options and impact on the hemlocks and warbler here, which FERC has not done? They've not opened the opened it back up for consideration.
Your Honor, the mission, the goal of the National Environmental Policy Act is to ensure that agencies undergo meaningful analysis of questions presented before it. And this court, in Wild Earth Guardians versus Jewel, held that agencies are not required to make the best decision.
How do you define what a hard look is? Have the courts ever tried to tell us what, the higher courts tell us what a hard look is? What's a hard look?
Your Honor, this court specifically has undergone a review of these agency actions on a case-by-case basis. Again, the Wild Earth Guardians versus Jewel held that agencies only need to engage in informed decision-making. And in this case, FERC's cumulative impacts analysis was sufficient because these two potential new pipelines did not have enough information at the time of the draft EIS or the final EIS.
Well, so why didn't FERC delay filing the final EIS once they got the other two pipelines pre-filing requests so it wouldn't be speculative, so that you could give a hard look to all three pipelines impact together?
FERC elected not to delay the publication of its final EIS for two reasons, Your Honor. First, as this court has pointed out in Citizens Against Burlington versus Busey, the construction of an EIS takes time and costs money. This has been a several-year endeavor from the initial proposal of the Mammoth Pipeline to its eventual final publication in May 2015. And second, it is an unrealistic mandate to require that FERC take an already nearly completed EIS that covers multiple different cumulative impacts and alternatives, and to put that complete EIS onto the shelf for some indefinite period of time until Me Too and NME know enough for themselves about the project.
I imagine it's on the shelf now, right? How long has it been in litigation?
Your Honor, it has been in litigation since the Wildlife Protection Council was originally requested for rehearing, and then.
So why wouldn't it have been more reasonable to just look at the impact of more reasonable and cost efficient for the agency to just look at the impact of all three pipelines together at the same time?
Primarily, Your Honor, because at the time of that draft or that final EIS, there was not even a known route for the Me Too or NME pipeline. In order to effectively analyze the environmental impact of a particular pipeline or any other agency project, the most important consideration for the agency is where the project is going to be. And the only thing that's reflected in the record about the Me Too and NME pipelines is that they are currently planning routes that are parallel to the Mammoth Pipeline. But there's no indication of what parallel means. There's no indication of how close these pipelines will actually be. The only thing that we know is that they're parallel, that they will not at any point intersect with one another.
Is there a mechanism to find out how close they would be to one another? You know, you reach a point where I understand your position about the fact that you've got a study that's, or a finding that's nearly ready for publication. But when you get material information like this, we're not talking about something remote. We're talking about two additional pipelines running parallel to the subject pipeline. It seems like it's pretty important.
Your Honor, if those pipelines, the Me Too and NME, run in a parallel form to the Mammoth Pipeline, say 10 feet, 20 feet, could even be within a mile of the Mammoth Pipeline, it's certainly possible that the new pipelines could run to an extent that would require that cumulative impact analysis. But simply, we know so little about these pipelines. We only know where they're going to start, where they're going to end, and their general goal of providing natural gas from Vandalia to Franklin. There's simply not enough known to provide that meaningful analysis.
But would you concede that it's pretty important to know a little bit about those two parallel pipelines? Wouldn't you just concede it's important?
Absolutely, Your Honor.
So if it is important, why not do what Judge Thacker suggested, give it some time, find out a little bit more information about it?
The question would be, what would be a reasonable span of time for FERC to put this pipeline on the shelf? This court in Theodore Roosevelt Conservation Partnership versus Salazar determined that agencies need not revise an almost complete environmental impact statement to accommodate new proposals, regardless of the uncertainty of maturation. In that case, this court held that even if the project is defined, and even if the new projects are certain, that an expert agency need not revise an EIS that is ready to be sent out the door.
So Mitu Energy and NME gas pipeline sound like people who would be under the jurisdiction of FERC in any event, right?
In all likelihood, yes, Your
Yeah,
Honor.
eventually. So again, picking up on my colleague's question, why not wait and send out, I don't know, requests for comments or interrogatories or something, say, tell us where you think this pipeline of yours or these two pipelines are going, and then consider. It seems to me that would be an effective and advantageous and maybe even cost-effective way to do it. Couldn't they have done that?
That's possible, Your Honor, and I'll respond in two parts. First, FERC is under no obligation to follow up with private companies to find out more information about projects potentially proposed before the commission. And second, that if these projects do reach the point, at some point in the future, that they have submitted enough information for FERC to begin the process of creating environmental impact statements for those two new pipelines, the cumulative impacts of both those two new pipelines in conjunction with the Mammoth pipeline will absolutely be included in those new EISs for the Mitu and NME pipelines. But until it reaches that point, if it reaches that point, and it's important to note that these new pipelines have only tentative contracts.
But it sounds like you're closing the barn door after the cows escaped, to put it in the vernacular. Why not consider the entire bundle? If FERC has jurisdiction, as Judge Stamp suggested, it would seem to be a small matter almost in the scheme of things to request the further information about routing.
I would disagree with that and would ask you, what would the bright line rule be that would help FERC determine at what point the trigger has been pulled to take it out of potential implementation and put it on the shelf? Because it seems to me that the rule we're considering possibly here would allow anybody at any time to submit almost anything as long as it's somewhat related, and that would stop the whole process, which would be great for competitors. And you put FERC in the position of having to determine, not having to determine something substantive, but rather just say, well, we stop.
Absolutely, Your Honor. Absolutely, and we are not advocating for a bright line rule. We're advocating that this court continue to comply with the case-by-case analysis that it has set out in the case law. And in this case, at a bare minimum, FERC would need to know where this pipeline is going to go. It needs some sort of route, similar to what the Mammoth pipeline
Well,
provided.
isn't the rule, though, before you know any of that, do you take this out of potential consideration and put it up on the shelf? But that's my question to you, and maybe I'm off base here, but it seems to me that if you don't have, it's the agency's, within the agency's discretion to determine if it has sufficient information, and then we look at that under an arbitrary and capricious review.
Absolutely, Your Honor. FERC, in its expertise, as an expert agency regulating pipelines, determined in good faith that there was simply not enough information known about the Mitu and NME pipelines, and rather than putting this project on the shelf for an indefinite amount of time until Mitu and NME reach the point where they, as private companies, are ready to move forward with these projects, FERC elected to move forward with its Mammoth EIS and the publication of that EIS, and then cover the Mitu and NME pipelines in separate EISs if and when they reach the point in that process. So regarding the second issue on appeal, FERC's alternatives analysis was also not arbitrary and capricious. Agencies are required to both clearly define and then follow their objectives. And FERC's objective in its Mammoth EIS here was twofold. First, in the purpose section of the EIS, as you stated, Your Honor, the purpose of the Mammoth EIS is to provide natural gas transportation service from suppliers in Vandalia to customers in the state of Franklin. And its stated objective in that EIS was to describe and evaluate reasonable alternatives to the project that would avoid or minimize adverse effects to the environment. And this court stated in Theodore Roosevelt Conservation Partnership that if an agency's objectives are reasonable, then this court will uphold the selection of those alternatives that are reasonable in light of those objectives. And this court in City of Alexandria versus Slater said that objectives must plainly take into account the needs and the goals of the parties. The objective combined with the statement of purpose strikes the right mix between the public policy goals under Franklin's Clean Energy Act, along with the goals of the Wildlife Protection Council of coming up with potential alternatives that would minimize or eliminate adverse effects to the environment. So if those objectives are reasonable, then the alternatives selected under those objectives should also be determined to be reasonable. This court in Citizens Against Burlington versus Busey stated that agencies need only discuss reasonable, but not all alternatives. And what the Wildlife Protection Council is requesting here is for FERC to predict far off in advance in the new landscape, in the post-Clean Energy Act landscape in Franklin, and to take an already complex electricity generation scheme and predict far off into the future what that electricity generation scheme might look like. The current electricity generation scheme is multifaceted. While 82% is currently generated from coal-fired power plants, the remaining 18% of electricity generation is split between 4 different electricity generation sources. And one of the stated goals of the Clean Energy Act is to take Franklin's...
And did FERC consider those 4 other energy sources?
It did, Your Honor. Those 4 currently existing energy sources are nuclear, wind, biomass, and solar.
It considered them individually, right, but not collectively?
Yes, what the alternative section laid out is it laid out the feasibility of a given alternative that would provide the same amount of energy that the Mammoth pipeline would provide. What FERC did not do is say 1% of Franklin's current electricity generation is provided by solar power. And the alternative of 100% of Franklin's electricity generation would now come from solar power. That would very clearly be an infeasible alternative. What FERC did is take a look at the currently existing alternatives and say, can wind power alone effectively replace the power that the Mammoth pipeline would provide? Can nuclear do the same? Can additional energy efficiency measures do the same? Can no action at all do the same? And FERC, in its expertise as an agency, and rather than predicting a combination of alternatives, say, will solar jump from 1% as it currently exists to 5%? Will it jump to 10%? Rather than predicting into the future what the future of Franklin's electricity generation scheme will look like, FERC took a look at the current landscape and said, will any one of these alternatives replace effectively the amount of power provided by the Mammoth pipeline? For these reasons, we ask that the court uphold FERC's decision to deny the petition for rehearing. Thank you.
Thank you. Petitioner, you've reserved some time.
May it please the court. First, a timeline clarification. There, in March of 2014, was when the Fish and Wildlife Service did their warbler survey, and in July of 2014 was when they issued their biological opinion. This is the last fact in the record that we know that FERC knew about. Now, opposing counsel mentioned that there's a possibility that FERC had heard about this aphid information. If that is true, then they failed the second prong of the arbitrary and capricious test, where they have not articulated a rational relationship between information that they had and their reasoned decision. And on this point alone, our petition for rehearing should be granted. Second, we agree with the FERC that there must be an analysis of economic factors, but FERC is not the proper actor to do that analysis. First, in 402.2, there's a discussion of the Fish and Wildlife Service evaluating economic factors when determining whether or not there would be a reasonably prudent alternative. This is to make sure that the Fish and Wildlife Service's consultation is actually helpful to FERC, that is providing reasonably prudent alternatives that are options. FERC then has 3 options of action: no action, choose one of these RPAs, or apply for an exemption. And that's not coming from the mind of the petitioners, that's coming from the Supreme Court, saying in the State Farm case that those were the 3 options. Now, under the exemption procedure, opposing counsel mentioned that this was just to create this committee. The purpose of the committee is to weigh these economic benefits. We see this in 1536 HA1. For these reasons, we'd ask you to grant our petition for rehearing.
Thank you.
May it please the court. We're going to look at the record here, and we're going to look at the cumulative impact analysis and the scope and the depth. When we first start off, we note that the respondents fail to articulate why it's not in the record that FERC considered a power line that was running parallel, but didn't consider these other 2 pipelines that were running parallel. And again, this is found nowhere in the record. Next, we see that on the record at page 9, while the respondents say that there is no mapping of these proposed pipelines, it explicitly states that in their pre-filing, mapping had begun. We move on to the scope and the depth of alternatives. We argued that of the 11 proposed alternative routes, not just the types of energy proposed as alternatives, of the 11, only 2 were considered. Respondents failed to address the other 9 and why they appear nowhere in the record. Lastly, not considering combinations is against the overall purpose of NEPA, to educate the public. We don't have a single source of energy that provides all of the electricity anywhere. It's always a portfolio, and to fail to consider that is arbitrary and capricious. So for these reasons, we ask that this court grant the petition for rehearing. Thank you.
Thank you. We'll retire now to deliberate and come back with our decision. All right, please be seated. Well, we were in there for a while because it was such a challenge for us, literally. It was very close. You all did amazingly well. I think the 4 of you should start a firm somewhere. I'm always amazed at the level of calm and confidence and skill and comfort that law students that do these moot court competitions have. And the 4 of you just raised the bar on that for sure. The 4 of you have just done something that I don't think I could have done in law school. I didn't do in law school. I'm not sure I could do it as well as you all have done it now, today. So I commend you, and I'll let the other judges have comments for you.
Well, I'll start off here. I'm the guy out here on the flank. I've been on the bench 25 years. I've judged moot court a lot of places, some of the top law schools in the Southeast. Judge Stamp and we've been married together some time ago. I've been to Vanderbilt, I've been to Washington Lee, and numerous other schools, and the 4 year as good as anybody I've ever had the opportunity to judge. You obviously were very well prepared, very much in command of the record and the authorities, and I really enjoyed your arguments, and the fact that all 4 of you did such a good job made it very, very difficult for us to pick a winner. I can't single out any one of the four of you as being outstanding, because you were all outstanding in my view. And it's been a real pleasure doing this, and I'm just sorry there has to be a winner and a loser. I know you're all winners because you've gotten this far. You've all won several rounds, but thought you all did fine. You answered the questions. You were calm and cool and confident, and that's about all I have to say.
Well, I won't take very long to echo what Judge Faber has said. I agree with all of it. And I would just say that, it's a tough subject matter. It's very timely. I learned a lot preparing for the arguments today. And I feel that there should be one more round, and you should be at the Supreme Court because you're ready for it. And so without further ado, my congratulations to all four of you. I agree, we struggled in there, and you should all feel that you won. Thank you.
One of the laments of senior lawyers and judges today is that there are fewer cases that end up going to trial for one reason or another, and fewer cases that are maybe put into oral argument. I've started trying to set some cases more for oral argument just so that I can have the chance to hear lawyers speak before a judge. And I would say that all four of you are ready to go, and I hope and wish you the very, very best. And all of us, are hiring law clerks, so don't hesitate to apply.
Well, this was a wonderful experience for me, I have to tell you. All the time I've been on the bench, I haven't seen better advocates. Having said that, I've only been on the bench 4 months. I have seen enough to know that when I ask lawyers questions, they routinely try to avoid them, evade them in some way, or not answer them at all, even ignore them. There have been times I've had to go back, thrice to get them to answer the question. Even then, it's not really a suitable answer. You all really did a terrific job, really terrific job of answering the questions. And I have to tell you, I'll probably not get invited back after I say this, but I actually tried to fashion questions once I was familiar with the material that I wouldn't necessarily been able to answer. And when I asked those questions and you all had an immediate reasoned retort, it made me feel a lot less intelligent. And that's a real feat on you all's part to have done what you did under these circumstances. A very intimidating setting. And we appreciate that, and you all are to be congratulated.
Let me follow up on one thing Judge Volk said. He said his comment about lawyers not answering questions. If you're an advocate, you should welcome questions. You should hope that you get questions, because that tells you what the judge is concerned about, and that gives you the opportunity to pare things down and address the specific thing that's on that judge's mind that might be the key to the whole case. So my advice to an advocate in oral argument is to welcome the judge's questions and try to answer them as fully and completely as you can, because that's what that judge is concerned about, and that's what he thinks that is important to the case, unless he's just being a jerk and trying to trip you up.
And there aren't any of those.
We do that sometimes.
I would like to just add one thing. I was telling the judges, I once sat with the Federal Circuit as a guest judge and had the honor and pleasure of hearing David Boies argue a case. And I would say you all were as effective as Mr. Boies in the way you took the questions, moved right into them, and we didn't get any of the telltale big eyes or intake of breath or not sure what to do next. So that's high praise.
And before we get to the much anticipated announcement of the winner, we just wanted to take a moment on behalf of this year's Moot Court Board and the faculty here at the West Virginia University College of Law to thank our esteemed panel of judges for being here today. So thank you so much for dedicating your time and making this final round an absolutely fantastic event.
We thought those for the art.
Oh, thank you very
Thank
much.
you very much.
Thank you.
Thank you.
Thank you, sir, very much.
Afternoon. I wanted to bring up Tim Miller. He's a partner at the law firm of Babs Callan, and thanks to their support, they've provided the financial support for the monetary awards which go with these contestants. And so, Tim, you want to come up and help us hand out the awards? And
Times have changed.
Chris, will you do that? Yes.
My former law school
Hey,
classmate.
hey, Tim, I wondered what you were doing back there. Oh, really?
All right, we've argued a lot. Oh, sorry. We've argued a lot. We've talked about warblers a lot. And at long last, it is time to announce the runner-up and the champion of the 2016 National Energy and Sustainability Moot Court Competition. To begin with, we would like to announce the runner-up. The runner-up for the 2016 competition is Team 6. Go ahead and give them a
You're like Team 6B.
And the champion of the 2016 Moot Court competition is Team 15. All right, everyone, feel free to stick around for some photo opportunities. There's been a lot of work that's went into this, and again, I'd like to take this chance to thank everybody who participated, everybody who judged, and everybody who has helped put on this fantastic event. And after you're done getting your photographs, there is a reception in the lobby with some hors d'oeuvres, so feel free to partake. Thank you again.
Finally eat. I have a question. We all want to know what schools you're from.
Yeah,
So when
we
we
do.
get your resumes, we'll know.
University of Pittsburgh.
Pittsburgh.
Yeah, okay.
Wonderful.
We're Washington.
Ah,
Wonderful. There you go. There you go. You made Judge Stamp very happy.
yeah.
Hey,